If you are a U.S. citizen who wants to bring your foreign fiancé to the United States in order to get married, you will need to file a Form I-129F, Petition for Alien Fiancé. This is the first step to obtaining a K-1 non-immigrant visa for your fiancé. The K-1 non-immigrant visa is also known as a Fiance Visa. In order to obtain a K-1 fiancé visa, you and your fiancé must intend to marry each other within 90 days of your fiancé entering the U.S. as a K-1 non-immigrant. Your marriage must be valid, meaning both you and your fiancé have a bona fide intent to establish a life together and the marriage is not for the sole purpose of obtaining an immigration benefit. If your fiancé marries you within 90 days of being admitted to the United States as a K-1 non-immigrant, he or she may apply for lawful permanent resident status in the United States, a green card. If you have already married, plan to marry outside the United States, or your fiancé is already residing legally in the United States, your spouse or fiancé is not eligible for a fiancé visa. Who are eligible for fiancé visas? You may be eligible to bring your fiancé to the United States on a fiancé visa if you meet the following requirements. If you are a U.S. citizen, you and your fiancé intend to marry one another within 90 days of your fiancé's admission to the United States on a K-1 non-immigrant visa. If you and your fiancé are both legally free to marry, this means you both are legally able to marry in the United States and any previous marriages have been legally terminated by divorce, death, or annulment, and you and your fiancé met each other in person at least once within the 2-year period before you file your petition. You may request a waiver of this in-person meeting requirement if you can show that meeting in person would violate strict and long-established customs of your fiancé's foreign culture or social practice or result in extreme hardship to the U.S. citizen petitioner. Step 1. File Form I-129F, Petition for Alien Fiancé according to the form instructions. This form asks USCIS to recognize the relationship between you and your fiancé. The USCIS may mail you a request for evidence if they need additional documentation or information. If you establish your eligibility, they approve your Form I-129F and recognize the claimed fiancé of your relationship. Step 2. Visa application. The NVC forwards the approved Form I-129F to the U.S. Embassy or Consulate where your fiancé will apply for a K-1 non-immigrant visa. This is generally the U.S. Embassy or Consulate where your fiancé lives. The U.S. Embassy or Consulate notifies you when the visa interview for your fiancé is scheduled. Your fiancé applies for the K-1 non-immigrant visa and brings the required forms and documents to the visa interview. The consular officer determines whether your fiancé qualifies for the K-1 non-immigrant visa. If the consular officer grants the K-1 non-immigrant visa, it is valid for up to 6 months for a single entry. If the consular officer does not find the relationship to be bona fide, they will not issue a K-1 non-immigrant visa and instead will return the Form I-129F to USCIS. Generally, if they returns a Form I-129F to the USCIS after it has expired, they will allow it to remain expired. However, you may choose to file a new Form I-129F. Step 3. Inspection at a port of entry, CBP. If the embassy issues a K-1 non-immigrant visa, your fiancé travels to the United States and seeks admission at a port of entry while the K-1 non-immigrant visa is valid. As with any visa, a K-1 non-immigrant visa does not guarantee admission to the United States. A CBP officer at the port of entry will make the ultimate decision about whether to admit your fiancé. Step 4. Marriage. If your fiancé is admitted as a K-1 non-immigrant, you and your fiancé have 90 days to marry each other. Step 5. Adjustment of status, USCIS. If you marry within 90 days, your fiancé, now your spouse, may apply for a green card by filing Form I-485, application to register permanent residence or adjust status. The USCIS will review Form I-485 and the documents your spouse submitted. You and your spouse will usually be required to appear for an interview. If you were married for less than 2 years at the time the Form I-485 is approved, USCIS will grant your spouse conditional permanent resident status and issue a green card valid for 2 years. Your spouse will need to remove the conditions on his or her residence by filing Form I-751, Petition to remove conditions on residence in the 90 days before his or her green card expires. If your fiancé has a child who is under 21 and unmarried, the child may be eligible to come to the United States on a K-2 nonimmigrant visa. You have to include the names of your fiancé's children on the Form I-129F if you wish to bring them to the United States. The children must continue to be unmarried and under 21 in order to be admitted to the United States as K-2 non-immigrants. They may travel with your fiancé or later, but they cannot travel to the U.S. before your fiancé. If you and your fiancé married within 90 days of your fiancé's admission into the U.S., your fiancé's children who were admitted as K-2 non-immigrants may also apply for a green card by filing Form I-485 with USCIS. However, K-2 non-immigrant children must remain unmarried in order to be eligible for a green card. K-2 non-immigrant children should apply for a green card at the same time or after your fiancé. After being admitted to the U.S. on a K-1 non-immigrant visa, your fiancé may immediately apply for evidence of work authorization by filing Form I-765, Application for Employment Authorization. In this case, your fiancé's work authorization is valid for only 90 days after his or her entry into the U.S. Your fiancé may also apply for work authorization at the same time he or she applies for a green card. In this case, your fiancé can file Form I-765 together with the Form I-485. In this case, your fiancé's work authorization is valid for 1 year and may be extended in 1-year increments. K-1 and K-2 non-immigrant status automatically expires after 90 days and cannot be extended. Generally, your fiancé and his or her children must leave the United States at the end of the 90 days if they don't get married. If they do not depart, they will be in violation of U.S. immigration law. This may result in removal, deportation, and could affect their future eligibility for U.S. immigration benefits.